Teaching Department of Law, Payal ma'am, give opening remarks, and will invite Honorable Vice Chancellor MNLU, Dr. Professor Uke sir, on the stage. Over to you, ma'am.
Thank you, Girish. Respected Professor Dr. Dilip Uke sir, my dear colleagues Girish, Vijayta, and all the teaching faculty, and all dear participants who have joined for this national webinar. A very warm welcome to you all from Postgraduate Teaching Department of Law, RTM, Nagpur University. Dear friends, the Postgraduate Teaching Department of Law was established in the year 1963, and today we marked 69 years of its inception. And throughout these years, the department was thriving towards achieving research and academic excellence by indulging into various aspects of legal studies, legal issues, and legal challenges. As you all are very much aware that in the postgraduate teaching department of law, we are having 7 specialization, which is very diverse in its aspect. And here we try to cover each and every aspect of law, which is very contemporary in nature, which is very burning, and which allows us to throw some light on the legal aspects of it. And one such topic which today we have discussed, we have identified, is the transformative constitution. Dear friends, we all are very much aware that since the last recent decade, if we see, we have seen a wide transformation, in the understanding of constitution, whether it is Navdeep Singh Johor's case, or whether it is Justice Puttaswamy's case, or whether it is Shabarimala judgment, and there are many such aspects which we have seen, wherein the judiciary has, it's not only judiciary, but of course the other stakeholders, who are contributing in the lawmaking, even all of them are trying to give us a new meaning of constitution, which is probably, we can say, that is the need of an hour, and probably the outcome of the social change which we all are expecting, to be there in the society. And for this particular topic, which is very complex, and I think one of the most difficult topics of today's time to discuss what do we understand by transformative constitution, we have none other than Honorable Dr. Professor Dilip Uke sir. Sir has very gracefully and very kindly accepted our invitation to be here as the keynote speaker for this national webinar. And sir, from the bottom of my heart and from the postgraduate department of law, I express my respectful gratitude to you for accepting our invitation to be there and to enlighten us all on this particular topic of transformative constitution. So over to you, Ujjwal. Thank you so much, sir. And I expect a lot more such discussions from you in the coming time as well. Thank you.
Thank you, ma'am. Good morning, everyone. I, Ujjwal Vasner, student of LLM 4th semester, PGTD of Law, Nagpur University. I feel privileged to welcome all of you for today's webinar on Transformative Constitutionalism, hosted by Postgraduate Teaching Department of Law, Nagpur. I feel elated to introduce our esteemed guest, Professor Dr. Dilip Uke sir, Vice Chancellor of Maharashtra National Law University, Mumbai. Sir is an expert in multiple arenas of law. Sir has completed his graduation in law in the year 1989, Master's in Law in 1991, and MA in Political Science and Public Administration. Sir was the only candidate to receive Junior Research Fellowship for PhD from UGC in 1991. Sir has been awarded PhD degree in law from Nagpur University in the year 2000. About Sir's experiences, Sir joined as a lecturer in the Department of Law of Pune University in 1993. Later, was appointed as a professor in Department of Law of Pune University in the year 2003. He was the head of the Department of Law of Pune University from the year 2004 to 2009. Sir was appointed and joined as a Pro Vice Chancellor of Swami Ramanand Tirth Marathwada University, Nanded in 2011, and later became the Acting Vice Chancellor of Swami Ramanand Tirth Marathwada University, Nanded in 2013. In 2019, Sir was appointed and joined as the Vice Chancellor Maharashtra National Law University, Mumbai. Sir has many achievements and awards. To name a few, in 2007, Sir was awarded Siksha Ratna Puraskar by India International Friendship Society, New Delhi. In 2009, Sir was awarded Best Citizens of India Award by Citizen Group of Publications, New Delhi. In 2019, Sir was awarded Best Law Academician Law Teacher Award by Indian National Bar Association, New Delhi. Sir has presented multiple research papers at national and international levels and conducted many seminars, conferences, workshops, and training programs. Sir has 28 publications till date and has published 2 books in 2020, and 1 is under progress. Sir has delivered more than 46 lectures with academic interactions on various contemporary legal issues of law. Sir has supervised 130 PhD and dissertations. Sir has discharged duties on various high-level committees of University Grant Commission, Union Public Service Commission, and State Public Service Commissions. Before I invite our honorable speaker, I have an important announcement to make for the participants of today's webinar. You all will have the opportunity to submit text questions to today's speaker by placing your questions in the chat box. The question will be addressed during the question and answer session at the end of today's webinar. Now, I would like to request our esteemed resource person, Professor Dilip Uke sir, to guide us on today's topic. Sir, I hand over mic to you.
Thank you, Mr. Ujjwal. Very fine good morning to all of you. Dr. Payal Tore, Head Department PGTD Law, Nagpur University. Dr. Vijeta, Mr. Girish, and other faculty members and dear student friends. It is indeed really a great pleasure and privilege to be with all of you on a virtual mode. It would have been a more pleasure had it been on a physical way. Nevertheless, the constraints which all of us now encounter, this is the way and mode to deal with, to handle with. At the outset, I congratulate Dr. Payal Tore and her team for taking the department further in its academic endeavors. Mr. Ujjwal, when he was introducing me, he introduced that which year I completed LLB, LLM, etc. But it is my bounden duty to share that I am myself a product of the same department. It was 32 years before. One can imagine the span, one can imagine the period. And though on a virtual mode, all those fond memories have been revived today. And that's what I said. I feel as if I am at home. Because always to everybody, every student, his or her alma mater matters more in his or her endeavors and journey, particularly in academic endeavor, particularly in academic life. So I owe so much to the department, law department, PGD law department, Nagpur University. When the invitation had come and asked about the topic, before I go further, I must mention that please bear with my voice due to some cold. Now it's all right, but otherwise 2 days before, till 2 days before, it would have been really difficult. I had to cancel 2-3 such webinars and meetings even. Rather, I was supposed to come to Nagpur on Monday and therefrom to proceed to Amravati University for some inaugural of the program on Tuesday, that was on 8th, but because of this I had to cancel. So please bear with my voice if it is it gives some irritation in between to my throat. Dear friends, when we talk about transformative constitutionalism, before that, all of us know when you talk about constitutionalism, that precedes with the constitution. Generally, we know that constitution is the highest document, highest law of the land. But what does the constitution do? What is the role of the constitution? Herein, first and foremost, we must know that what constitution does is that it organizes not only the life of the society, but primarily it creates the state, it creates the government. Having created the government, then organs of the government. Having created the organs of the government, then assigns the functions to each of the organs of the government. Having assigned the functions to each of the organs of the government, then confers powers upon each of the organ of the government. And having conferred powers upon each of the organ of the government, then it places certain limitations, restrictions, or stipulations upon the exercise of those organs. There lies underneath the notion of constitutionalism. Constitutionalism is otherwise, as we know and understand, that it is the limitation or it is a limited government. Constitution would not allow, doesn't allow an exercise of an arbitrary power. Either it is legislative power, or it is amending power, or it is an executive or administrative power. Those powers are supposed to be exercised within the framework of the Constitution. That's why the beginning of the constitutionalism lies therein itself, that what is the role of the Constitution. Of course, it differs from the kind of a polity, kind of a nature of politics, or kind of nature of the legal system which is there existing in a particular state, in a particular country. But wherever, more importantly, it is a democratic and more of liberal democratic setup is there. As we say, liberal democratic civilized societies are there, wherein constitutionalism plays a very, very vital role, very, very pivotal role. As we know that constitutionalism is nothing but the limited government. It is not the limited governance which shall make the distinction. It is a limited government, not the governance, wherein the functionaries, authorities ought to, as I said, exercise their power in accordance with the Constitution, in accordance with the law. When we say in accordance with the law, it doesn't mean that in accordance with the written text of the Constitution or in accordance with the written law or words of the any act or legislation. But even there are certain constitutional conventions, as we say, which are there, which evolved rather over the period of time. Even those conventions are also equally important. And that's why it is necessary to understand firstly, before we speak about transformative constitutionalism, it is necessary to understand what is the meaning of, or what is the status of, or nature of constitutionalism per se. So it limits, it restricts, it stipulates the exercise of the power of the state, of the government. And that's why once we look at these from jurisprudential point of view, from jurisprudential perspective, Girish will be more happy about to listen this, to know about this, that even the Constitution itself is the product of the natural law theory, in a sense that look at the social contract. particularly the Hugo Grotius social contract, who crystal clear, it has been pointed out by him that constitution of every state has been preceded by the social contract. Social contract is an actual fact of human history. I'm quoting Hugo Grotius, the natural law lawyer and the social contractarian. Social contract is an actual fact of human history, and every constitution has been preceded by the social contract, wherein the people make the constitution, draft the constitution in accordance with the social, economic, political circumstances existing at that period of time, point of time in that particular society. Try to understand here what he had said. I reiterate, I would repeat. Constitution has been preceded by the social contract, and people, please underline, people make the constitution, draft the constitution in accordance with the social, economic, and political condition existing then at that particular period of time, point of time. So herein, try to understand that who makes the constitution? It's the people who makes the constitution. That's what rather Hugo Grotius had pointed out, the great jurist even of international law, public international law. Principle of pacta sunt servanda. That is nothing but, I would say, quote unquote, international constitutionalism. So constitution itself is the product of people's will, people's mandate, wherein then people take into account while making the constitution, while drafting the constitution, social, economic, political, and all other conditions or circumstances as they exist then. If that is so, when it is so, look at the preamble of the Indian Constitution. What it says that we the people of India having solemnly resolved to constitute India into sovereign, socialist, secular, democratic republic and give to its citizens liberty, equality, justice, liberty of thought expression, equality of status, belief, justice, social, economic, political. So who make the constitution? Who has made the constitution? We the people. That's what rather Hugo Grotius is the pioneer of this ideology, that constitution has to be preceded from the social contract or by the social contract. Therein itself, as the notion of constitutionalism, when we talk about, which limits the exercise of the powers of the government, we know when we look at, again I would say that before we speak about transformative constitutionalism, I would like to highlight few things about the constitutionalism, then we will switch over to move to transformative constitutionalism. As it appears that it limits, constitutionalism limits the powers of the government. Look at the Constitution, Indian Constitution, Article 13. State shall not make any such law which shall take away the rights guaranteed by this part of the people. It is limitation, it is the express notion of constitutionalism. Article 13 is a positive express notion of constitutionalism. State shall not make any law. Embargo has been placed, limitation has been placed. The powers of lawmaking have been curtailed, restricted by the constitution itself. So that is the notion of Article 13, is the notion of constitutionalism. Not only that, as we know, whole part 3, as we know well, all of the rights, Article 14, 19, 20, 21, 25, 26, likewise. Those gamuts of right, as Article 21 says, no person shall be deprived from his life and personal liberty except according to due procedure of law. We'll come to that later. Again, herein, the power has been sought to be limited. Sought to be limited by what? Sought to be limited by the principle of due, just, reasonableness, fairness. Let us go back to the jurisprudential foundation. As rights are important by virtue of rights, which we call today as fundamental rights, the powers of the state powers of the government have sought to be restricted, limited, and thereby constitutionalism, notion of constitutionalism has been ingrained expressly in the constitution. Therein too, when the theory of natural law was on the verge of emergence, at the same time, the theory of natural rights was also on the verge of emergence. And looking at the whole gamut of natural law theory, we'll come to know that, like Professor John Locke, the social contractor himself, he has also given so much primacy, importance, significance to right to life, along with the property. In a way that rights have become a kind of a parameters. Natural, fundamental, basic human rights have become the kind of a parameter to limit, to restrict, to stipulate the exercise, particularly legislative as well as executive administrative powers of the state, of the government. That is nothing but the notion of constitutionalism. That's what Professor again John Finnis of the natural law theory, natural law lawyer, a great natural law lawyer, he talked about 7 basic common goods. For him, natural law is nothing but the practical reasonableness. And those 7 basic common goods also contain like life, knowledge, play, aesthetic experience, sociability and friendship, and religion. Practical reasonableness and religion. Those are the 7 basic common goods. According to him, any exercise of a lawmaking by the state has to adhere to these 7 basic common goods. No law can violate, no law can be in contradiction with these 7 basic common goods, in a way that 7 basic common goods are nothing but the limitations, stipulations or restrictions imposed upon the exercise of not only lawmaking power but even an exercise of an administrative power of the state. What does this, what these indicate, what these show? These are nothing but the gamuts of, these are nothing but the aspects of or facets of constitutionalism. We know well from transition from Gopalan to Maneka. That's what I said, look at it later. Gopalan, wherein the Supreme Court then had refused to treat the word due as just, reasonable and fair. The argument was rejected, rightly, wrongly. Obviously, it was wrongly. That argument was rejected. That due process clause contained ingrained in Article 21 is equivalent to, similar to the 5th Amendment of the US Constitution. But that argument was rejected on the ground that rather the word due was there earlier in the draft constitution, draft article, which was removed subsequently by the makers of the constitution. That's what Supreme Court judges said. How we can read the thing which was there, which was removed, how we can read immediately after the commencement of the constitution thereafter. Of course, this is not the place to go in all the details, but as all of us are aware that thereafter the transition from Gopalan to Maneka, the same argument was advanced, wherein the Supreme Court had accepted and interpreted liberally the notion of due process. Procedure established by law also includes due process of law, substantive as well as procedural both. What is this? This is nothing but the facet of instance of Maneka is nothing but the facet or instance of the constitutionalism, notion of constitutionalism. There are several such instances, like even in Gopalan itself, dissenting judgment delivered by Justice Fazal Ali. Justice Fazal Ali's dissenting judgment is the majority judgment of Maneka. So rather, beginning, even no doubt, legally, constitutionally, dissenting judgments do not have that kind of a value or bindingness. Nevertheless, they do contain so much value. They become a leading lights for the future. Like Justice Fazal Ali's dissenting judgment became the leading light in Maneka, majority judgment in Maneka, or quote unquote law declared by the Supreme Court within the meaning of Article 141. So Maneka is nothing but the law declared by the Supreme Court in the dissenting judgment delivered by Justice Fazal Ali in Gopalan itself. Similarly, we look at the dissenting judgment of Justice Khanna in ADM Jabalpur versus Shivkan Shukla. Same way, same manner, same fashion. Even though the national emergency we imposed under Article 359, the fundamental rights are suspended, but at least access to justice, recourse to the judicial process, that cannot be negated, that cannot be negated, that cannot be taken away under any circumstances. Of course, as all of us are aware, that that was his dissenting judgment. But dear student friends, I must mention at this juncture that dissenting judgment subsequently not only, rather it was overruled recently in Puttuswamy expressly. Justice Y.V. Chandrachud, who was a part of the majority in ADM Jabalpur, Justice Y.V. Chandrachud, who was a part of majority in ADM Jabalpur, Justice D.Y. Chandrachud, who was a part of majority in Puttuswamy. Rather, Justice D.Y. Chandrachud, he himself said that it was not the correct interpretation on the part of the judges in ADM Jabalpur by the majority judges theory. So, son has overruled the father for a right reason and reasoning us. When we say this, there are multiple instances, and impliedly, indirectly, I am referring to, or I would say I have referred the notion of transformative constitutionalism as well. But before that, when we say this, when we talk about constitutionalism, I do not wish to referring to Dr. Bonham's judgment delivered by the House of Lords in the year 1610. During our days, there was a specialization in constitutional law in PGTD law department. One paper was on British Constitution. In that classic judgment, as hopefully we are aware, that earlier Great Britain didn't have the written constitution. Now it is there. And since there is no constitution, there is no question of constitutional limitations to be imposed upon the exercise of legislative or executive power of the state. So whatever the parliament thought fit was to be a law. It was not the constitution which was supreme there as it is here in India. It is the, as we say, as we study also, supremacy of the constitution is one of the basic principle of the Indian constitution. Then it was, since constitution was not there, no question of constitutional supremacy, but rather it is the supremacy of the parliament, parliamentary sovereignty, which was one of the basic principle of British constitution. Another adage was that British Parliament is so powerful, so supreme, so superior that it can make a law which might turn a man into a woman. Just to denote how powerful it is. During such period, during such scenario, in spite of such a power being possessed and exercised both by the British Parliament, Lord Chief Justice Coke in 1610 in Bonham's case, Dr. Bonham's case, held that any law enacted by the Parliament, if found to be contrary to the basic rights of people, individuals, or immoral, then despite of the parliamentary sovereignty, such law could be declared as invalid, illegal, unconstitutional. Dr. Bonham's judgment stands for the notion of constitutionalism as well as even transformative constitutionalism. Not in real sense, but implied. Because as all of us know, 1215 Magna Carta was there. 1689 Bill of Rights was there in Great Britain. And that's why, to uphold, that's what we said initially while looking at the jurisprudential foundation of the notion of constitutionalism, that rights play, people's right play Call them as natural, call them as fundamental, call them as basic, human, whatsoever. They are the facets of constitutionalism. They place limitations, restrictions upon the exercise of legislative as well as executive powers of the state. It cannot be exercised, both the powers cannot be exercised in an arbitrary manner, fanciful manner, no. Because rights are important. Basic rights are important. That's why they are basic. That's why they are natural. That's why they are fundamental. In view of this, Dr. Bonham's judgment delivered by Lord Chief Justice Coke in 1610 assumes some significance. Similarly, the US Supreme Court in 1803 delivered a landmark judgment. We had a paper also then on US Constitution, special paper on US Constitution. In Marbury versus Madison, Chief Justice Marshall held that any law enacted by the Congress, it is their parliament, they call it as a Congress. Any congressional legislation, if it is found to be violative to the basic fundamental rights of people, then despite of such a separation of powers theory, this court has a power to declare such law, such act as unconstitutional, invalid. Look at these two judgments from two different countries. One was having a written constitution, still is having the written constitution. Other one did not have the written constitution. In spite of that, highest court of the lands at both the places upheld the notion of constitutionalism while upholding the rights of the people. In a nutshell, it means that the basic goal, basic object of the notion of constitutionalism is to protect the basic rights of the people. No doubt constitutionalism is there, but what it achieves, what it does, for what it is to be there, it is to be there for this. But this is a qualified statement. Reason is that it largely depends upon that's what I have said initially, largely depends the kind of the nature of the polity or legal system which exists there. See, all of us have studied jurisprudence, sociological jurisprudence propounded by Professor Roscoe Pound. He also said that his theory would be applicable, operative only in a society which is a civilized society, which is a matured society. It cannot be applicable, cannot be operative, cannot be functional in dictatorial regime. That's what. The nature of society matters. Nature of polity matters. Nature of legal system matters. And therefore, democracy, rule of law, constitutionalism, and even constitutional morality. When Indian Constitution was in making, Dr. B.R. Ambedkar, who delivered the speech on 4th November 1948, if one reads Constituent Assembly debate, would come to know, did talk about the notion of constitutional morality. It is the constitutional morality which is the basic foundation of constitutionalism. It is the notion of constitutional morality which is the basic foundation of transformative constitutionalism. That's what I said. Notion of democracy, rule of law, constitutionalism, and now transformative constitutionalism. These are the four pillars of the civilized society. Liberal democracy, liberal polity. Thereby, when we talk about democracy, of course, there are different versions of constitutionalism. I do not wish to go in all those details because of the paucity of time as well. Liberal constitutionalism is there, illiberal constitutionalism is there. There are some other versions. Professor Rosenfield did talk about that, but I will be crisp. When we talk about transformative constitutionalism, particularly, to my mind, Indian Constitution, when it was being drafted, at that juncture itself, not only constitutionalism, the notion of transformative constitutionalism came to be incorporated or inbred in the Indian Constitution. As the deviance between constitutionalism and transformative constitutionalism is such. Rather, it was again, when we talk about democracy, which kind of democracy do we talk about? Democracy in a state wherein the majority may turn constitution upside down on the basis of brute majority. India has experienced, witnessed that during the period of emergency. So therefore, rather, though it could be little out of way, when we talk about transformative constitutionalism particularly, it is necessary to understand that firstly, Dr. Ambedkar did not accept the definition of democracy as we all of us are aware about Abraham Lincoln's. It is the government for the people, of the people, and by the people. No. He said it is not, firstly, it is not this definition which is conducive to our own state, our own society, our own country. Rather, according to him, the democracy is nothing but the form and method of the government whereby revolutionary changes in social and economic lives of the people would be brought without any bloodshed. Dear friends, according to me, to my mind, the genesis of transformative constitutionalism is nothing but the definition of democracy as provided by Dr. Ambedkar. I would reiterate again. Democracy is the form and method of the government whereby the revolutionary changes in social and economic lives of the people would be brought without any bloodshed. So it is evolution, not the revolution. Social and economic lives of the people are to be transformed. Positive changes are to be effected in the social and economic lives of the people, and that too without any bloodshed. And that is the job of the government, that is the role of the government. Hence, in view of this, India represents the notion or facet of the transformative constitutionalism. US doesn't. Of course, at a later stage or impliedly, one could say that yes, it is also now following the notion of transformative constitutionalism, because it has to do something with even the social welfare era, a transformation of the society, social change which is to be effected in society. Primarily, notion of transformative constitutionalism is in the origin from the South Africa. As the country having 85% black people was ruled till then, adhering to apartheid by the white people. And that's why when that apartheid was coming to an end and the new constitution was to be drafted, from that past of agony, from that past of strife, conflict, tortures, killings, injustices, violences, to the future of happiness, of equality, of fraternity, of justice. That is the way the constitution was to be drafted, and therefrom, rather, the notion of constitutionalism came into origin, came into beginning. Rather, it was former Chief Justice of the South African Supreme Court, Justice Lenga, who had used the term transformative constitutionalism first time. What it seeks to achieve, as we are referring to the definition of democracy provided by Dr. Ambedkar. It is the government, it is the form and method of the government whereby revolutionary changes in economic and social life of people could be brought without any bloodshed. But according to him, it is not the political democracy. It is the social democracy. Unless we adopt, unless we follow social democracy, political democracy would not have any fruitful meaning as well as relevance. If transformation of the society is to be occurred, then social democracy is needed. And what is social democracy according to him? Social democracy according to him is nothing but the way of life. Social democracy is nothing but way of life which respect liberty, equality, and fraternity. It is the way of life. Social democracy is the way of life which gives respect to every individual's liberty, equality, and fraternity. The notion of fraternity which has been ingrained even in the preamble of the Constitution, assuring the dignity of individuals and fraternity, assuring the dignity of individuals, and that's what rather the notion of social democracy, wherein underlies the notion of transformative constitutionalism. As the past which has been inflicted by discriminations, which has been inflicted, riddled with tortures, riddled with inequalities, riddled with killings, violences, injustices, heaped over the period of centuries together. In South Africa, it was apartheid. Herein, it was caste system, as all of us know, which divides the country, which divides the society, which divides people. Even after 70 years or 75 years, we are celebrating Azadi Ka Amrit Mahotsav. We have to search where is that Amrit now. So therefore, transformative constitutionalism stands for transformation of the society. Our in the sense, everybody is, irrespective of class, caste, religion, region, so on and so forth, must be treated equally, with equal respect, with equal dignity. That notion of equality, which is to be a kind of a basic foundation of the transformative constitutionalism. It is not only limitation of the powers of the government as well as the exercise of the power of the government, but rather even empowering, enabling the government to effect that transformation which is needed. And that's why the notion of positive discrimination, which is permissible in transformative constitutionalism. As we say, the constitution is the document. It is not only the law, but rather it is a charter of not only rights, charter of social change, charter of social transformation. There are various such provisions ingrained, provided under the Indian Constitution. And there are very general. Wherein the question is, does the judiciary play any role in this? Or it is the Constitution per se, Constitution alone has to play that role. Of course, looking at, as I said, that it is an ocean. It is not confined. Neither it cannot be described. Rather, notion of transformative constitutionalism is itself a definition less. This notion itself is definitionless. For me, it could be one. For you, it could be another one. For a different one, it could be different one. It is which kind of aspect we wear and from which how we look at as well as understand. It depends upon that, and thereby even doctrine of basic structure. That is also the notion of constitutionalism as well as transformative constitutionalism, though not in its entirety, but to large extent, it is the notion of constitutionalism as it was evolved in Keshavananda Bharati, which limits not only the lawmaking power but amending power, as well as enables both, enables as well as limits both. And that's what rather, that's the reason what I say that it is a facet of constitutionalism, doctrine of basic structure, not only constitutionalism, but at the same time even transformative constitutionalism. Transformative constitutionalism not only limits the power of the government, arbitrary exercise of legislative or executive power of the government, but at the same time it enables, empowers the government, empowers the state to come out with various welfare measures or positive laws for the benefit, we would say a kind of a beneficial legislation, welfareistic legislation, wherein judiciary also plays a very, very vital role, very, very pivotal role. Few of the cases which have been referred by Dr. Payal Thore. That in Navte Singh Johar, as you know, rather Nas Foundation, the Delhi High Court firstly delivered that judgment by Justice A.P. Shah, that whether Section 377 is doing justice to. Because when you talk about rights, what about the rights of that minority? In a transformative constitutionalism, every unit, based on whatsoever the ground, based on whatsoever the parameter, is to be taken into account, is to be considered. Every unit, we may call as the third sex or whatsoever. What about the rights of those people? Are not they human beings? When we talk about morality, as even Justice Chandrachud said, it is not the popular morality we shall look at, but rather we shall look at the constitutional morality. He said so in Navte Singh Johar itself. Rather, Justice Chandrachud, D.Y. Chandrachud, he used this expression that Indian Constitution is transformative in nature. Rather, I would say, and brand, all of us, not me, all of us. I had a great opportunity to interact with such a great legal luminary, Justice Krishna Iyer. He had visited then the department, and I could spend some time with him. Those who have gone through judgments delivered by Justice Krishna Iyer, for him, what was important? For him, it was basic human rights. It was a compassion, as he used to call karuna. Everyone has to have the karuna, a compassion for each other. That's why. It was Justice Krishna, I would say, who started the movement in judiciary of the transformative constitutionalism. Of course, there are various others, Justice Vochinappa Reddy and all others, wherein the notion of transformative constitutionalism connotes that positive changes have to be effected in the, I would use the terminology provided by Dr. Ambedkar, in social and economic lives of the people without any bloodshed. How to make lives better, social and economic life better of every segment. It is the least advantage in Rawlsian version, Professor John Rawls, his difference principle. It is the greatest happiness of not the greatest number, but the greatest happiness of the least, LEA, least advantaged person. That's what the notion of transformative constitution is. Wherein, as Navtesh Singh Johar said in ultimately, as we know, NAS Foundation to Suresh Kaushal and Suresh Kaushal to Navtesh Singh Johar, wherein Dr. D.Y. Chandrachud said that Indian Constitution decriminalizing Section 377, not completely, as you might have studied or you will study, not completely, but rights, basic human rights, fundamental rights, which are available to every individual, irrespective of anything, by the law, and that too, such colonial law. They might have scrapped also, rather they did it 40 years before. We took so much time. So similarly, even Sabarimala, again, Young Lawyers Association, again, Justice D.Y. Chandrachud used the term that Indian Constitution is transformative in nature. Because the reason is that in case of the transformative constitutionalism, basic fundamental natural human rights of individuals are required to be protected, are required to be promoted, are required to be safeguarded. No doubt the constitution is there, but the interpretation of the constitution, as we know, lies ultimately in the hands of the highest court of the land, particularly. And thereby, judiciary plays a very vital, very important role in shaping, I would say, in as what constitution does. Constitution not only construct, in case of transformative constitutionalism, constitution has to reconstruct the society. The society which is erected upon divisions, society which is erected upon discriminations, society which is erected upon conflicts, injustices, inequalities. This is required to be reconstructed. That is the role of the constitution, to reconstruct the society when the constitution is in existence. And that's why the transformation occurs not only by way of constitution. When we say transformation occurs not only by way of the laws which are to be enacted by the state. Transformation occurs not only by the judicial decisions, which are also the laws within the meaning of Article 141 in any society. If you really want to celebrate 75th year of independence, Azadi Ka Amrit Mahotsav, as I said, the question we need to beg that are we able to get that Amrit? No doubt transformation is there is no denial of the fact. But that vicissitude, reason, as expressed then by the constitution makers, nation builders, how the India as a society, as a nation, is to be constructed, is to be built, is to be progressed. Whether are we in a position to achieve that? Duty doesn't lie, duty doesn't rest only with the state. We are also under the duty. We are also under the legal duty. We are also under the constitutional duty. We are also under the moral ethical duty. If we look at the post-apartheid period of South Africa, when the constitution was made, of course, because of, as I said, that because of the lack of time, I will skip several things, and rather I would like to conclude also in a minute. That state alone, judiciary alone, government alone, laws alone, constitution alone cannot do anything. Look at the notion of fraternity as engraved in the preamble. Fraternity and assuring the dignity of individuals. Is it the duty of the state only to assure the fraternity or to assure the dignity? What is fraternity? Fraternity is, all of us know, is nothing but the common brotherhood. Look at Article 51AE in the form of fundamental duty. Every one of us have had a glance of fundamental duties. Look at Article 51A. It is provided there. Each one of us under the fundamental duty. And as we are obsessed with our rights, my rights are fundamental. I must be able to enforce, enjoy, exercise. What about my duty or duties which are also equally fundamental? Am I aware about those duties? And even if I am aware about those duties, do I discharge or try to discharge those duties? Do I really follow that notion of fraternity? Do I really follow that notion of common brotherhood as a fundamental duty imposed upon me by the Constitution? That is the question which is to be begged. It is a matter of introspection for all of us. As Dr. Ambedkar said then, it is not the untouchability which is to be eliminated. It is to be the caste system which is to be eliminated. If we see around, less said the better. That's why. When you talk about constitutionalism, particularly transformative constitutionalism, judiciary will do its role. Judiciary will perform its duty. State will perform its duty. But equally, we are under the constitutional fundamental duty to effect that transformative constitutionalism. Each one of us is responsible, accountable for this transformation to be happened, to be effected in this great Indian civilized liberal democratic society. With this, I conclude. I do understand that because of the paucity of time, it is not possible to refer to everything. So floor will be open for constitution for question answers.
Thank you, sir. We will now attend the questions from the participants. Dear participants, please post your questions in the chat box below and do fill the feedback form at the end of the session.
Participants, if you have any queries, you can raise your hand and you can directly ask that question as well if you have not written in the chat box.
Good morning, sir.
Good morning.
Uh, at the concluding session, you had told that Dr. Ambedkar was not of the view that there should be a caste system. Rather, he was not of the view to eliminate the untouchability, rather to eliminate the caste system. But after 70 years of our constitution, we are just globing around the caste system. What should be done, or how can we come out of it?
We have heard carefully. That's what I said. The notion of fraternity which is there in the preamble and the fundamental duty which has been casted upon us under Article 51AE, we need to treat each other as our brother, sister, without looking at his or her surname. But that doesn't happen. It is not the state which is going to come to everybody along with the stick. No, it's my own conscience. It's my own duty, which I need to perform. But if I decide not to do, of course, state is not going to compel. You must compulsorily have to have the friendship with him or her. No, that is freedom of choice. Intentionally, I mean, as I said that there are several some other decisions, including to submit. I mean, it could be multiplied. Decisions could be multiplied. That is not the aim. That is not the goal. Goal is this. It is for us to do that. Unless you and me decide, each one of us decide, that is not going to be how it is to bend, and it is forward. That's what I said. After even 75 years of independence, that's what the reason I said that I'm in search of that real elixir, real Amrit. Why there is not peace so much? Why there are violences? Why there are discriminations? Why there are divisions? Why there are terrorist activities, so on and so forth. We have to enlighten our own conscience. We are human beings, but with due respect, sorry to say, we do not behave like a human beings. We behave like what? That is understood. Rather, I am on record to say this, particularly when I speak about human rights. Why human rights violations occur, or even why this such apartheid, or all those things occur? Because all of us have studied Darwin's theory of evolution in our school days. If you remember that how the human being has been evolved, it's a evolution, theory of evolution, right from single cell amoeba till this in human form, human avatara. So man has undergone all the phases. It was chimpanzee also before becoming a human being. So that tail is disappeared, hairs were disappeared. Instead of 4 legs, 2 were converted into the hands. Likewise, we have undergone all these, but unfortunately what happened, that even though from all those phases we have become an in the form of human being, the body is in the form of human being, but the qualities remain those of animals. See, it is not the duty of the human being to bark. It is the duty of the dog, quality of the dog to bark. Still human being barks. It is not the quality of a human being to bite. It is the quality of a snake to bite. Still human being bites. It is not the quality of a human being to kill. That is the quality of a tiger or a lion to kill. Still human being kills human being. Therein lies the answer.
Thank you, sir.
So we have another question for the participant. It's from
What is the question?
yes, sir. It's from Prakash Kumbare. Is it necessary to read the Constitution textually while interpreting and implementing the Transformative Constitution, or only to ensure social equality?
Question is over?
Yes, sir.
Okay. Yes, it is necessary to read the text of the Constitution. Reason is that unless power is there, what you are going to interpret? Unless something is there, what you are going to apply? It is a liberal interpretation, not a literal interpretation. That's what rather the transition, as we referred to, from Gopalan to Maneka. In Gopalan, it was literal interpretation. In Maneka, it was liberal interpretation. But for either literal or liberal interpretation, thing is to be there. Unless thing is there, I mean, unless the text is there, unless the provision is there, what you are going to read, what you are going to interpret, what we are going to apply. Of course, there could be some occasion, like say Vishaka, when though it is not there, still that could be read. There are several such things that came to be read under Article 21, like Vishaka, freedom from sexual harassment at workplace. Nevertheless, the Supreme Court therein had invoked CEDAW. Supreme Court had invoked Article 142 in Vishaka to do the complete justice, to pass an order to do complete justice. So CEDAW was there, Article 142 was there. It was a liberal interpretation accorded by the Supreme Court in Vishaka. let down those guidelines, 10, 11 guidelines, declaring those guidelines as a law till the time Parliament enacts the suitable legislation with this effect. Vishaka was decided in 97. Act came to be enacted only in the year 2013. It took 16 years, but it was because of the judgment delivered by the Supreme Court. Due to liberal interpretation, it became possible.
Hello, may I may I ask, sir?
Yes, please.
Sir, there is due to the changing globalization, most of the powers which was earlier exercised by the state only, like controlling the media and all, are vested in the private hands. And sometimes the private media or sometimes the social media hand in the hands of the private companies, they restricts the people from expressing their rights. There may be certain discriminations as well. So, can we extend the constitutionalism even to exercise the rights of the people which are generally available against the state only, even against those private persons?
I missed out initial part. Nevertheless, I understood what is your question. That can we invoke the rights against the private persons which are available against the state? Vishaka
Yeah,
itself, dear friend,
yes.
Vishaka itself at workplace, Supreme Court did not say public workplace. Even Vishaka is applicable for private place. That is one. Secondly, Bodhisattva Gautam versus Shubhra Chakravarti, if you have read it or heard it, wherein Article 21 was invoked by the Supreme Court none other than against the husband itself. Article 21 was invoked against this by the Supreme Court against the husband himself. Just imagine. These are the two judgments, landmark judgments, and of course there are there, which amply, because of which it is amply clear that even the rights are otherwise which are available against the state, even could be made available against the private parties, private individuals. That
So there was,
here, yes, please.
sir, there was a interesting issue. The state is limited by restrictions 19.2, and some companies is restricting the speech and expression without referring to 19.2. Can their action be called as unreasonable and therefore void?
See, ultimately, it depends upon the judicial interpretation. As I said, rights, fundamental rights, not rights, fundamental rights also would be available against private parties as it is, clear on the basis of Vishaka as well as Shubhra Chakravarti. So ultimately, it hinges upon the interpretation, liberal interpretation rather, accorded by the judiciary. But nevertheless, yes, it can be.
Okay. So the scope is still permissible to be opened for
Yes,
private person.
it is there. It is there, permissible.
Next. Thank you very much, sir. If you permit, some of the questions we can take. Sir,
Yeah.
Sir, there are few questions in the chat box. If you permit, we can take few more.
Yes,
Means
we can.
yeah. Okay, Ujjwal, go ahead.
Thank you, ma'am. Thank you, sir. So we have a question from a student named Kanchan Kumar Shevale. The question is, directive principles of state policy, not justifiable, but fundamental in governance, how it connects with constitutionalism. So can UCC bring spirit of brotherhood and gender justice?
See, we talk about relationship, about fundamental rights and directive principles of state policy. Primarily, there are three phases or three stages. No, where in the first phase it was held that it is the fundamental rights which are more important than directive principles. Second phase, directive principles were more important than fundamental rights. Thirdly, both are complementary and supplementary to each other. That is one. Secondly, whosoever asks the question, I must tell you that are all that though by constitutionally they have been made as non-justiciable, nevertheless there were several occasions, say like Asian worker case, wherein the Supreme Court held right to receive wages is a fundamental right under Article 21 itself. Directive Principles of State Policy speaks about only living wage. That has been invoked. Otherwise, it is a statutory right. If you read Asian worker case, People's Union for Democratic Rights versus Union of India, wherein Justice Bhagwati and again Justice Krishna Iyer were delivered the judgment, the PIL, which was, wherein that directive principle was invoked, used, and elevated to the status of fundamental right under Article 21. So it means that they play the role of transformation. It is the transformative constitutionalism. It has been already used. That's why intentionally, deliberately, I said while concluding or just before that, judiciary plays a very vital role in this while shaping the transformative constitutionalism. Fortunately, Indian Supreme Court herein was active and has been active about this.
Thank you, sir. We would take this last question from Colin Bajpai. His question is, if we study the Indian Constitution, then one can notice that the Article 232 was never made part of it. Why is it so, sir?
Article 232, what it is?
I will repeat the question. If we study the Indian Constitution, the one we can notice that the Article 232 was never made part of it. Why is it so, sir?
Article? It has not been made what?
Sir, the question is
Sir,
that
that's,
Article 232 was never made a part of Indian Constitution. So the participant wants to know the reason why it has not been made the part. I think it is related to appointment of.
That was
Ma'am, I
substituted.
presume this question is totally incomplete at the moment.
That was substituted.
We can take another question also. I mean, if this question
Yes,
is
ma'am.
not clear.
Thank you, ma'am. I will proceed with another question from the student.
The last one.
Sir, it's from Pranali Pahade. Her question is, sir, people are posting at the moment. So give me a moment, sir, please. So you told about evolution of government and not revolution without any bloodshed. So, sir, things going around global related to war and the headline which are coming up, what will government do, evolution or revolution?
Question is a bit, so ambiguous or so much vague. No, it is for every state, So that has nothing to do with the constitutionalism or transformative constitutionalism. It is a general question. I believe that ultimately the state authority has to decide about the interest of their own country, about the interest of people of their own country, as well as their sovereignty, security, etc. I believe this question is asked referring to present war going between Ukraine and Russia. If that is so, there are this is a public platform, but political reasons, international politics is also involved therein. There are several other reasons. It's not what we see or what we read in the news. It is not that alone. Certain things we cannot comment upon on public platform. They are not what we see or what we read in the news. They are not those things alone. Behind that, there are several other factors which are responsible, which they consider and which they have considered. Who is right, who is wrong, that part. Of course, any war is bad. That revolution, if at all it is not a revolution, it is a war. That is bad. No one would say that any war is good, unless and until it is so much so needed for the protection. All right.
Can we take one more last question, sir, please?
Yeah.
If you may allow, sir.
Yes, quickly.
Yes, sir. I will be quick, sir. So, how long this reservation system will continue is asked by Vaishnav Varade. And does it increase casteism by uniting caste identity? Example, Maratha reservation, Jat reservation, etc.
See, when Article 16.4 was provided under the draft constitution, it was not Article 16, it was Article 10. It was not the word backward classes, but rather particular classes. That word particular was substituted with backward. Keeping in mind recall what Hugo Grotius has said, social and economic conditions existing then in that particular society, constitution is to be drafted, made. And that's what rather our makers of the constitution sought to do then and did it. So keeping the conditions then, social conditions then, they have made this provision. However, gradually, then it has become a kind of a tool in the hands of the people who are at the helm of the affairs, and it has become even a tool of politics, of vote bank politics. So that's why this is not the purely constitutional or legal question, it is a political question. Quote unquote political question. If you know the doctrine of political question, earlier, of course, it is no longer there. Supreme Court used to refrain from answering the political question. Of course, it is not at all now there as such, but ultimately it is for the government of the day to decide. As I said, that it is not only political, it is not only legal, it is not only constitutional, it is political question. It has been made as a political question. So again, it is that what it comes to conscience. If we refuse to abide by the conscience, or if we refuse to have the conscience itself, then nothing can be done. So ultimately, it is the human conscience. It cannot be injected. Conscience cannot be injected. Conscience cannot be implemented. It is for each one of us. Be it judiciary, be it government, be it political party or parties. But everybody is craving for the power, greed. So everyone can't renounce the world. No, I don't want the power. Would any political party would say, no, we are not interested in political power. No. So that is the reason. That is the naked, harsh, unfortunate reality of this quote unquote civilized, liberal, democratic Indian society.
Thank you so much, sir. Due to time constraint, we hereby conclude question answer session. And I would like to invite Girish sir for formal vote of thanks. Sir, to you.
I hope I am audible.
Yes, yes, you're
Yes,
audible.
sir. As always, your words makes me nostalgic of the very fortunate period when I was able to learn in the lecture halls. The natural law, as we know, it's the history of mankind. History of mankind is nothing but a history of natural law and his search for absolute justice. This transformation in the constitution, which we are talking about, or the aspiration for a better civilized society, which is to be evolved through the efforts of law, and not only law, but all the members who was making the social contract at the time of constitution framing, they also have to perform their part of contract to realize this constitutionalism as such. I would like to express the deep sense of gratitude from my side, from the postgraduate teaching department of law towards you, so that you have shared your valuable time with us and given us the glimpses and intricacies of constitutionalism, and more so the transformative constitutionalism. There are challenges and there are opportunities as well that you have explained to us about the evolution of Indian society. There are hard realities as well that you have shown in your answers to this questions. Thank you, sir, for explaining us and giving us your knowledge, sharing with us your knowledge about this issue. I also thanks to the head of the department for giving us an opportunity to listen such a luminary in the field of law and gaining the knowledge from his ocean. Then I'll also thank for the organizers of this webinar and all my colleagues, because of whose constant efforts or webinar could have been organized. I have to thank to the technical team, without whose presence and continuous alert assistance this session could not have been conducted. Thanks to all of you from the bottom of my heart, and thanks to you, sir, for again sharing your time and giving us an opportunity to listen to you and to forget ourselves in the field of legal interesting knowledge. Thank you very much, sir.
Thanks to all. Thank you so much. It has been a privilege, really wonderful to interact with you all. And because of constraint of time, rather I could not cover other things as well. So hopefully sometime, part two, sequel.
Indeed, sir. Yes.
The sequel of this part has to be there.
Yes, yes.
Thank you, sir. Thank you from all
Thank
of
you.
us. Thank you so much.
Thank you so much. All the best. All the best to all.
Thank you. Thank you very much, sir. If we, with your permission, may I conclude the session?
Yes, please. Thank you.
Thank you. Now we ends the sessions here. Thank you all of us. Thank you all of you for joining here. And the feedback form will be posted in the chat box. Please fill that feedback form so that you will get the participation certificate. The link is posted in the feedback chat box.